Hey everybody, today's estate planning question is what if a life tenant of a home in an asset protection trust goes into a nursing home? The answer in a moment, but before we get there, please consider a close friend of yours and that perhaps they could be going through a what if scenario that creeped into their lives currently. However, they were fully prepared because you shared our video. We would appreciate it, and so will your friend. I'm Valerie Zammitti, an estate planning attorney in New York and New Jersey. We're here to educate everybody for free, and to that end, we hope that you share your questions so that we can help answer them for you and for others, so that we can save people together before something pops up in their life. Now, to the answer of what happens if a life tenant of a home and an asset protection trust goes into a nursing home. So there's really two concepts here that we need to consider. The capital gains impact, as well as the possible Medicaid impact. Now, any good estate plan will have what's called an intent to return home provision built into it. That means that the individual, even if they do end up in a facility outside of their home, has an intention to come back to that home. And that alone typically, and it does depend on the state and what we're talking about, what area of law, but it typically means that there's still a connection between that individual and their home. For capital gains purposes, that means the home will still be included in their estate at their passing, and the family receives what's called a stepped-up cost basis at their death to avoid the capital gains consequence. But you need to consider that if a family member winds up in a nursing facility and then you decide it's best to sell the home, you want to consider, and this is selling the home, of course, during their lifetime, you need to consider the difference between their purchase price, including capital improvements, and what the sale price is going to be, as that difference is considered a capital gain. However, because it was, say, that parent's primary residence, you need to make sure that they meet the qualification that they were a resident of that home for at least 2 of the last 5 years. So you want to sell it within 2 years, essentially, so that they would receive what's called a $250,000 residency capital gains exclusion. And that way, any difference between the cost and improvements and the sale price will shrink by that $250,000. And you'll have a lower liability, if one at all. Now, on the Medicaid side, you do really need to look at how the states are implementing the intent to return home. It's my understanding, although I'm not licensed in California, that they have now eliminated that as a benefit on the Medicaid side, meaning that I presume that means that they will come then after the home in an easier fashion. But you have to check with your state council on that. So an intent to return home, though, if it was out of the hands of the individual for typically 5 years, again, depending on the state, for nursing home Medicaid eligibility, then that resource is not counted and will not be considered by Medicaid, and then presumably never have what we call a Medicaid lien placed on it at the passing of the individual who received benefits. We hope that information has been helpful to you, or it will be for a friend. Please don't forget to share. And as always, take care.